Hello, everyone, and welcome to the second webinar of the CPLJ project. And I'm very happy today to have with us a number of scholars. But first, let me introduce myself. My name is Margaret Wu. I'm at Northeastern University School of Law. I'm one of the lead editors of the CPLJ project. And along with me are the other lead editors, Burkhard Hess, Louis Cartier, and Enrique Falanes. So today's webinar will focus on critiques of comparative law. And just as a matter of background, reformers and scholars have historically used the technique of comparison, but the term of comparative law was not introduced until the end of the 19th century. But countries like Japan, China used this comparative method in the late 19th century in the establishment of their modern legal system. And I'm hoping that Timu Raskala, one of our speakers, will talk a little bit about that. But we also know that the European Union utilizes the method in many of its harmonization projects. But today we're going to hear from two scholars, both critiques of the traditional methods of comparative studies. So, just as a matter of background, beyond mere doctrinal comparison, which is what we are attempted to do, there are fundamentally two different methods of comparisons. That is the functionalism and the cultural legal comparisons. And functionalism focuses more on the idea that if law is seen functionally as a regulator of social facts, then the legal problems of all countries are similar. And every legal system in the world is open to the same questions, subject to the same standards. So the focus is on functionalism, on similarities, and has been the basis for the classifications of legal families based on functions. Now, by contrast, the other traditional method of comparative study is cultural comparisons, sometimes called comparative legal studies. And it rejects the reduction of law to its functions, instead seeks to understand national law as an expression, development of its general culture. So it focuses more on differences and legal traditions. So we are going to consider some of the critiques of these two kind of traditional comparative methodologies. And before we start, though, I'd like to remind everyone of the kind of rules and protocols. Please consider raising questions even during the presentation, but do it through the chat. And in the chat, you can indicate whether this is a question on a comment or a comment using the letter Q or C. And within the chat, indicate the subject matter of your question. This way I can group certain questions and comments together, and I will call on you. And once I call on you, our very astute moderators here will help to unmute you, and I would ask you to raise your hand so that we can pick you out of the crowd and unmute you, and you can ask your question verbally to the presenters. Now, one other item is that your screen can be adjusted in case you're not aware, because I know the Horatio Muir is going to show some slides, so you could move your mouse on the screen and adjust it so that you could both see the screen and each other, other attendees in whatever proportion that you find most useful to you. So those are really two tips about how we can run this seminar more smoothly. So why don't we start now by beginning with a presentation from Horatio Muir Wald. And we're very lucky to have her with us today. She is the tenured professor of Science Pole, where she is also co-director of the program Global Governance Studies. She is a member of the Institute of International Law, a longstanding member, and a member of the Institut Universel de France since 2018. So let me turn it over to Professor Watt.
Thank you very much indeed, Margaret, and thank you all at the Max Planck for this very generous invitation. I'm very, very flattered. Obviously, it's difficult to see that it's difficult to say that I'm happy to be here, because of course here is neither here nor there, and this is obviously a piece of metaphorical comparative standard discourse, because comparative law is about the here and the there, and very often we end up somewhere in between, which is, I think, where we are now, unfortunately, although of course getting together such an impressive number of people might have been more difficult actually in sort of real life physical conditions. So I'm going to ask for the help of Nicole to share the screen. And I'm going to talk to you about comparative law beyond the pale. Now, I'm not sure that everybody understands the expression, or perhaps the concept of beyond the pale, but the idea of the pale is something like an enclosure, right? It has a similar etymological root to palisade or palier or things like that. And the idea here is that I'm going to be doing something a little bit different. In other words, something perhaps that I don't usually do in my day job. I'm going to take the invitation to look at civil procedure as an invitation to try and imagine how to do things, not with rules, but with comparative law, particularly in the field of civil procedure. Now, yes, I definitely take on board the critique of comparative law as very much emblematically expressed in the readings that have been communicated to you today. But I'm not going to go back on these specific critiques. I think they have been done and so well done that I definitely couldn't add to them. What I'm going to try and do is see whether there are further horizons or other forms of cutting edge, let's say, where comparatists could be doing useful and interesting things. And I'm very grateful actually for this invitation to think about civil procedure in these terms, because it has, in thinking out what might be interesting to a procedural audience, let's say, or an audience specialized in civil procedure, which is definitely not my case. And at the risk precisely of going over the top or going beyond the pale, I am going to be talking about trial studies. Now, trial studies is certainly something that's not part of the conventional curriculum, definitely not in Europe and even less in France. Something that beyonds, I think, to the budding discipline of political and legal humanities. And trial studies, focus on trials as their name indicates, are not designed to compare procedural institutions as such, nor are they usually actually conducted by lawyers. Although lawyers may play a marginal role in the global assemblage of disciplines that come into play here. But the trial studies assemble disciplines such as literature, philosophy, political theory, epistemology, psychoanalysis, to look at the trial as the place where the judicial machine, as it were, comes into its own. So the sort of very specific and emblematic expression of the law. I think one can think about many exercises in studying trials as trial studies, even if they don't necessarily present themselves as such. And in thinking about the topic, Philippe Sand's recent book on East-West Street came to mind. It's a literary piece. It's also a historical piece and a piece about international law, of course. But to a certain extent, one could put it under this rubric. Now, the idea, of course, is that trial studies present other lenses through which we can look at the working out of a judicial or jurisdictional, if you like, machine. And the idea of other lenses, of course, fits very well with a very basic idea of comparative legal studies. And Nicole, I think we can pass to the first slide here. Give you a little. Thank you very much. This picture, you may recognize it as Dali's representation of the metamorphosis of Narcissus. I think it shows very well, first of all, the idea of the uncanny, which it's meant to illustrate, but also something about the feeling of sameness and difference, which is very much captured by comparative law or certain ideas of comparative law. The idea then is that comparatists look at law and keep a sense of strangeness. And I think that trial studies very much help us to do this. Obviously, it's not new that good comparative law has a lot to do, for instance, with historical studies of law, less in a technical sense than in ways of making precisely our present strange in a certain way, or rather, or perhaps we could upset it or put the lens in the other way around and say our own pasts are extremely strange. There are obvious examples here again. I'm thinking, for instance, of Aldo Schiavone's account of the invention of Western legal reason, where he shows us how easy it is to forget the extent to which our mindsets have been formed by our pedigree in Roman law, and bifurcations or binaries such as nature and culture may well go back to Roman divisions. An even more extraordinary example is P.G. Monateri's book, Dominus Mundi, which tells us about the deep ontological change that took place in Western thought with the disappearance of this very legal idea, legalist and rationalist idea of the Dominus Mundi. And the point of my mentioning these is that these are both studies by lawyers with extraordinary historical and other erudite knowledge, but they convey this extraordinary sense of strangeness about our own practices. So what is interesting about trial studies is that it seems to me that they, using interdisciplinarity and a lens of, or a sense of cultural diversity, they avoid the flattening of legal comparisons that's very often endemic to traditional studies. They show up things happening under the surface that traditional studies don't usually do. Now, if Nicole, we could have the third slide, please. Great. I think one of the emblematic and, for me, eye-opening accounts in comparative law by a comparative legal scholar is William Ewald's well-known article from 1995 called "What Was It Like to Try a Rat?" I think it's probably unnecessary to underline to what extent this brings in a sense of the strange. Of course, he's talking about medieval Renaissance animal trials. And its the main point of the article, which is a very, very long article, is about linking up comparative law to jurisprudence. Actually, in his case, analytical jurisprudence, but that's really beside the point. What I think it brings to us now is that it points to the procedural unfolding of such trials, such strange trials, as an encounter, as a point of encounter between the purely technical, what did the court look like, how did it function, what sort of arguments were exchanged, and then the transcendent. There was something very metaphysical to say about this, this trial. And more generally, I think it points to the fact that a procedural move, such as changing a rule, for instance, think of changing a rule of standing. Let's open up to inanimate objects or corporations or states or whatever. They may well be signaling within the law more widely a deeper metaphysical change. And this change, of course, takes on different forms from culture to culture. In the rat trials, the fascinating thing is that the rats were protected by the most extraordinarily powerful and highly modern procedural arguments. In other words, the rats and the grasshoppers and the pigs and the wolves were given in many instances an equitable or fair trial, habeas corpus in the case of the rats. And they won, which is quite an amazing thing. So I'm going to take this cue that exists already within comparative legal studies, which of course are extremely rich, to look at procedure more closely and its very extraordinary and strange, ritualized, formalized mode of existence. And when I'm talking about mode of existence, I'm referring very directly to a term that is used in anthropology, and particularly, this is my reference, in Bruno Latour's Anthropology of the Moderns, where he not only points out, and we only have to look at our trials today to realize this, that we have actually never been modern. And moreover, that law has its specific mode of existence. So I'm trying to use civil procedure here, or procedure more generally, to think about what is exactly specific about legality. How does it help us think about law's own ontology or its own mode of existence in respect, say, and I'm taking up one of Latour's 15 categories, in respect, say, of politics. That's a recurring obsession of lawyers, right? Where do we start? Where does law stop and where do politics start? And how do is law just a form of politics, or is there something else in there? And another category with which today we may be worried about how it relates to law is, of course, technology, tech in Bruno Latour's categorization, because, of course, the arrival of digitalization, the use of big data in predictive justice creates an anguish among lawyers, I think, as to where law stops and where the technological starts. So I'm going to, as from now, very informally, as you can see, try and play a little bit with 4 different intellectual frameworks through which to view trials. And the idea is that this can help us more specifically to think about the significance, as it were, of the procedural cogs of the judicial institutions in terms of their social, cultural, political, and other significance. And so I hope you'll bear with me. these cogs appear in the account that's going to follow as a perhaps unlikely but very interesting place to observe the specific dynamics of the same and the different within law. And of course, the same and the different, you'll have seen from the readings, is one of the great ideological divides between comparative law lawyers, because there are those who are looking for the same and those who are aware of the difference. It means a lot about, if we're looking at procedure, it means a lot too about rethinking or thinking about the divide between form and substance within the law. Any interdisciplinary exploration obviously has a certain arbitrariness about it, because you have to select the disciplines that you're being interdisciplinary with. And so I have done something extremely arbitrary. I've taken the letters, the 4 letters of the Pale, and I'm going to have a look, first of all, P for politics, A for anthropology, L for linguistics, and E for epistemology. And we'll see whether those, among many other things, I was going to play around with trial, and then I thought I'd maybe go beyond my time. So could we have the first slide, please, Nicole? The first slide is about the political economy. I'm going to go quite quickly because I'm aware of time, but these are conversation points merely. Okay, so we can come back to this in the discussion. I'm just trying to share some things that I think are interesting about doing things with law. So the first idea, the political economy of the law, is how power plays out in the courtroom. And obviously there are many ways of looking at this. We could look at the actors within the courtroom and the way the judge obviously exercises power, may also exert some kind of domination over the other actors, many things like that. I'm more looking at the courtroom itself as a dense transfer point in a kind of a Foucauldian language, and a very instructive place to look at this as an example is the colonial courtroom. And I'm inspired to do this merely because there's a fabulous book that's just been published by Cornell University Press by an author called Judith Serkis, called Sex, Law and Sovereignty in French Algeria, 1830 to 1930. And this is not a work of law. It's not a piece of legal scholarship in a strict sense. But it is so instructive, I think, for lawyers. It studies a very impressive historical archive of cases that, among other things, of the judgments of the Court of Appeals of Algiers during this particular time. And one of the very interesting things is in many of the rather blithe studies in comparative law or private international law, which is of course one of my lenses, none of this ever comes out. So actually one of the messages, the ways in which the affirmation of French colonial sovereignty during this long period, well, a whole century of colonial rule, how French colonial sovereignty works together with affect and sexual desire that finds expression in law, legal institutions, and within the courtroom. It's fabulous. And from the perspective of trial studies, it's interesting because it provides an example of how court procedure goes hand in hand with substantive moves. And we can see here the law working out such categories as personal status. Private international lawyers will be familiar with this. As a strategy of imperial rule. Now, Timu, of course, knows far more about this than me, and his works, I think, have inspired many, including Judith Serkis herself. But what is quite extraordinary is the way in which the French colonial state assumed authority over local Algerian tribunals and actually changed the nature of procedure, and particularly civil procedure in those cases. It circumscribed the authority of the muftis and the cadis who were functioning locally, transformed their function, and at the very same time, in a curious mixture, as the book shows, of repulsion and envy, personal status and property, the whole machine created new legal categories with extraordinary distributional effects in terms of power and privilege, which are still here to look at today. And the archive goes through the judgments of a certain president of the Cour d'appel d'Alger, who had an extraordinarily long record. And of course, it's an analysis of discourse and of the outcome of the decisions. So that's one way in which, it seems to me, trial studies might be able to widen our perspective. This very book has been published under the rubric not of law studies, but of political humanities, which is so very interesting. We're going to go to the next point now. We'll take the A of pale. And the next slide is about anthropology. Now, this may be far more familiar terrain to specialists, of course, of civil procedure. First of all, it's not new to look at civil procedure in general as ritual, of course. And I'm sure most of you know far more than I do about the historical, let's say, ancestry of various procedural institutions in archaic medieval forms, such as orderlies, for instance. I think that's a traditional part of legal history and anthropology. I think perhaps more generally, there's been much interest about the magic of legal formula as they work out in the courtroom. And of course, I can think of Kantorovic's great study on the ecclesiastical or liturgical and legal functions that combine in formula. So sort of the sancta, 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 the religious investiture of the Byzantine emperor was also actually a form of legal institution. And the two are totally inextricable. And that, of course, leads to very interesting insights into a form of legal, I'm trying to find the word, political theology. That's what I mean. Political theology through the working out of procedure and formulaic discourse. I think furthermore, if we widen still, the anthropological dimension helps us obviously to think about the various cultural expressions of procedure and central topics such as orality or the written word within procedure and within the courtroom. The interesting thing about magic formula is that they're both very concrete, as legal procedure is, but of course they contain something magic or ineffable that explains their very power. Sancta, 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 or oyes, oyes, or other legal formula obviously are highly performative, in fact, magically performative. There again, to go back to P.G. Monetary and another of his books on the geopolitics of law, he shows how the non-written dimension of the very oral common law procedure encapsulates, as it were, something that is ineffable and beyond words within this particular cultural form of the law. And then a third point is that looking at the courtroom as a place of rituals leads the whole fascinating idea that rituals help co-produce a world or a universe. And this leads us to the idea that was invented or promoted at least by Mariana Valverde of the courtroom as a chronotope. And I'm putting that obviously in inverted commas and borrowing him from her. It's a chronotope is a very specific combination or a particularized combination between time and space. And one of the particular chronotopes that she analyzes is precisely the courtroom as a universe, as of its own chronotope with its own time and space dimension, spatial dimension. So in terms of trial studies, this is all, of course, important, and we could go perhaps back to animal trials. Now, I evoked earlier, I think, Eval's foundational piece, but this piece in comparative law, but the piece had great success and was taken up in legal theory, for instance, by Gunther Teubener, who used it to think about new moves in what might be called the new political ecology. In other words, the question of standing of such thing as trees, to go back to Peter Stone's classical study that I'm sure you're familiar with, trees, but also chimpanzees, rivers, idols, and perhaps nature itself or herself, however one would like to characterize the gender of nature. And this example is interesting because it shows us how rules on standing can help us think about the various ways, the various moves that law could make in order to establish imputation. In other words, it's a place where we can start thinking about how we could imagine a new political ecology of legal planetary responsibility or liability, if you like. The standing is, of course, a way in which the third guarantor, in other words, in modernity, the body politic, the state, is present in the courtroom through the oracle of the judge. But thinking about the standing of nature takes us perhaps to the idea that this third guarantor might be beyond the body politic as a state, nature as a far wider and more important, perhaps less artificial, I don't know, category, prefiguring the legal order of Gaia, as they say, or as Latour says anyway. Could we now turn to the third slide, the L of pale, and I'll turn to linguistics. Now, here again, this is a very familiar topic to comparative lawyers because, of course, the analogy between law and language, both in jurisprudence, wider political philosophy, and comparative law is a recurring feature. What interests me here is studies, particularly contemporary studies, from a historical rather than actually a purely linguistic perspective on the idea of lingua franca, which is there again, it's a classic of comparative law, but lingua franca means many things. And there's a return today in the context of what has been characterized, as everybody knows, as civilizational conflict between the East and the West, or between the Muslim world and the Christian world, or there are many ways of characterizing this. It's a return to what is believed to be the authentic lingua franca, which grew up in the Mediterranean. And when I say in the Mediterranean, obviously across the Mediterranean and perhaps on it, among sailors and other traders, diplomats crossing the sea, that grew up at the time of the Crusades. And what interests me here in these studies is the idea of the lingua franca as an in-between space. Now, and I'll come back to trials in a minute. The idea of an in-between space, there again, probably needs quite a lot of explanation. But what the historical studies have come up with is the idea that the lingua franca, as it was practiced, was not attached to a given community or a given identity, or made to carry certain values other than communication itself. And yet it had its own linguistic structure. In other words, from a linguistic point of view, it's not a pidgin and it's not creolization, it's something else. It has its own existence. And what interests me here is that it's a space of communication that coexisted with extreme conflictuality. And that seems to me a very, very interesting way of thinking about trials and the way that civil procedure works out during a trial. It's a place of in-between conflict and communication. And so one could take this in many ways, many metaphorical ways, of course, but thinking about the language of procedure and the survival of Latin, for instance, in the civil procedure of many countries in surprising places, for instance, is a way of thinking about the use of a specific procedural language that could be a sort of in-between space. That topic is of particular interest to me because I'm trying to think of private international law as a go-betweener, as something that links up different spaces, let's say. But I think that procedure does this job too, and that thinking metaphorically about procedure could, there again, open a new imaginary about the work of law in between spaces. It's both interstitial, but yet it's very, very central. And as you may know, the lingua franca that was used over sort of practically from the beginning of modernity to somewhere in the 19th century, it was not a language that replaced others. It was a language that people used in addition to their own. It was a language of exchange and communication. And it was used by military, by diplomats, by traders, by seamen, but it was also used in judicial procedure. And I think that there again, the archive is not, it doesn't appear to be all that rich in terms of historical studies, but there were trials in the ports, for instance, where the judges were using the lingua franca to be able to judge these disputes that sort of in some ways crossed over the seas. I'm now going to turn to epistemology, thank you, Nicole, for my last letter in pale. And here we turn to a completely other thing, where I'm going to talk about the idea of legal proceedings as a good place to observe law's epistemological boundary work. Now, law's boundary work, there again, I'm borrowing a term that's been very much used in science and technology studies and law. Asking about law's boundary work is asking how legal work carried out in courts might contribute to create categories, create divisions, of course, that's the boundaries, pales, but also categories. You can't have a category without boundaries. And the focus here is the use of law's boundary work, or the working out of law's boundary work, if you like, to establish such categories as scientific. What do we mean by the scientific? And of course, within the courtroom, this means identifying what we mean by scientific expertise. Now, here again, I'm referring to work, and in particular to the work of Sheila Jasanoff, who is, as you probably know, a very leading figure in law and science and technology studies, and in her States of Knowledge, which is already a fabulous title, because it draws attention to the links between the political, the social, and the scientific. She studies a particular case that concerns the legal status of scientific evidence in the courtroom. So there are several interesting things here. First of all, Jasanoff uses what she calls the idiom of co-production. So this idea is, how do legal protocols, including procedure, impact upon scientific knowledge, and the other way around, conversely, how scientific ideas create social order, or if you like, have an impact on the legal ways of understanding or creating knowledge. And the trial study here is an article in her book, which focuses on a real life case. So this is a 1993 case before the US Supreme Court, called Daubert. I'm sure you don't pronounce it like that, Daubert, perhaps. Which was about a tragic issue, which is about birth defects in babies caused by the use of a medication called Bendectin by pregnant mothers. And the long and the short of this is that the Supreme Court instructed the lower courts, as from there, to become gatekeepers, as it were, of reliable scientific methodology. What is reliable scientific evidence? Well, that's anybody's guess, because there's nothing more uncertain than scientists getting together to work out some kind of scientific outcome. And actually, the COVID crisis shows us that science is understandably uncertain. But in the legal imaginary, it's not. And here's the Supreme Court asking the judges, as it were, to think of scientists in a legal imaginary of science as being able to sift out what is certain and what isn't, what is reliable and what isn't, in terms of scientific evidence. And this goes far, of course, in creating a specifically legal category of science in a procedural context. Obviously, too, and this is one of the points that Jasanoff makes, this boundary work done by the law works out or operates very, very differently from one cultural context to another. And so what may be a legal definition of science or a legal conception of what scientific evidence is, say in a US context, is going to be extremely difficult, different and probably difficult in, say, a French context. You take several examples here, but there again, we could look at COVID to see how different cultures actually understand what scientific procedure actually is. So now I'm going to pass on to my concluding slide, which is a picture of lichen or moss. And you may well wonder what on earth this has to do with all the rest, trials and procedure in general. And so I'm going to come back to my very first point, or the point that I made in the introduction about unflattening comparative legal work. I have just mentioned law's boundary work. And this leads me back actually to Latour, if you like, and the quest for law's specific mode of existence. And I think that procedural lawyers can understand this insight extremely well. One of the things that Latour says, without in any way meaning anything negative about this, is that one thing that's very characteristic of law's own mode of existence as compared with others, such as politics or technology or whatever, is its superficiality. Now, this is interesting because, of course, usually when you say that this is a superficial study, or what I've just been doing is pretty superficial, actually, because I've been chasing through ideas rather on the surface, it's usually a very negative judgment. But when Latour says that law is superficial, he doesn't mean anything, anything weak, let's say, about the law. On the contrary, he is very impressed. He says that in his latest book on the body politic. He's very impressed by the way in which law, rather than other modes of existence, such as politics, has always maintained its specificity. So what is this special feature of law that is superficial, or doing superficial work? Well, as proceduralists, I think, can perfectly well understand, it means that law can pass through and connect anything. And when I say anything, that means any type of events and existence or actors and things. And actually, if you go back to Justinian's code, and that's a very European thing to do, but there again, that's our heritage, or that's our pedigree in the Western world. We know that the code had a sort of a universalizing ambition to govern a whole universe of people and things and actions. Well, that's what law does. It connects them up. And there are various metaphors that are connected to this. The idea that law is a ligature. Law is something that repairs broken links. It connects up, it works along the chain of events and people and things, reconnecting and repairing. In other words, law passes. And this is where the lichen comes back. And I really like this picture because it looks a little bit like a map of the world, or some kind of a geopolitical comparative map of legal systems that come up in different colors in a fairly random way. But law passes through all that, and that is how law functions. So if we go back to trial studies, which was the sort of central message of what I've been trying to say, I think that one thing that we can get from them, and when I say we, that means comparative lawyers, I'm talking as a private international lawyer, and I hope this is sort of significant also for procedural lawyers. And that means that taking the trial, in other words, the procedural cogs, seriously and very seriously, they appear as not only, as it were, the nitty-gritty, something actually one that the mechanics, the sort of the less noble part of the law's functioning, if you like, it is also a profoundly metaphysical object. So thank you very much. That's what I have to say on comparative law beyond the pale.
Thank you so much. This has been, this was a fantastic and cogent presentation. I want to remind everybody again, if you have questions, to put it in the chat, and then indicating whether it's a question or comment, and I can call on you. You will be unmuted so that you can ask your question orally. So while we're waiting for the queue to form, I do have two questions, actually, because this has been so stimulating. So it's fantastic, because what you've taken us to is saying, rather than functionalism, rather than looking at trials and asking what function does trials serve in a legal system, and rather than looking purely at legal traditions and culture, that is, how does trials reflect certain history in which it is formed, you have brought us to a broader category of intellectual framework, that is to look at trials in terms of the power that it plays, in terms of the performance aspects of it, in terms of the lingua franca dominance of it, and in terms of its boundaries, epistemology, right? So that we can look at that from these four different intellectual framework, and that's terrific. So one question I have is, so what I'm hearing is really how you do the comparative methodology. But Roscoe Pound wrote like 70 years ago, says that much of, not all, in comparative studies depends on what is compared and how it is compared. So one question I have is whether you have any more specific kind of recommendations as to how we select what is being compared, because you've nicely put in these additional frameworks as to how we do the comparison. But one question is whether you have any thoughts about what is being compared and how we avoid the problem of flattening in our selection of what's being compared. And then the other question I have is your final conclusion, which when you say law connects and passes, I have to say, I might disagree with that, because it seems to give a very passive characteristic to law. I mean, law constitutes reality as much as it reflects it, and as much as it simply connects and passes. So, you know, I'm hoping that you can kind of elaborate a little more on that, because in my mind, it seems to give too little kind of recognition to the both the constructive and destructive power of law.
Right. Thank you, Margaret. Those are fantastic questions, unsurprisingly, but they're great. So how to select an object to do interesting non-flattened comparative law? That's practically an impossible question, because it depends on what I think sort of perhaps one should flip the question and say, whatever you're working on, whether, I mean, in civil procedure, you're working on evidence or in judicial injunctions or rules of jurisdiction or whatever, orality, you can always unflatten by bringing in a comparative aspect. I think that's one of the ideas of why comparative law, and there's been an argument for a very long time why comparative law ought to be part of the curriculum, because by using a comparative perspective, one denaturalizes. In other words, one can bring in a sense of strangeness in order to look at anything that seems absolutely obvious, dry, technical, and usually it isn't. On the other hand, I'm not sure that one should go out there selecting an object to do comparison, let's say. I don't think that's how comparative lawyers do. They do it really the other way around. However, to a certain extent, you're right, that's what I have done. But it's just because I was trying to put myself in the shoes, let's say, of a civil procedure person who might be listening, and focus on an interesting thing that's going on out there. That's not necessarily new everywhere. It's new in more conventional places like over here, but it's one particular application of interdisciplinarity, I think, that comparative legal studies encourage. I'm not quite sure that's a helpful answer, but I'd like to pass to the next question about law's passage, the passage of law. I think that there you're absolutely, obviously, law does more than transparently pass through, of course, and law certainly constitutes, law co-produces, to go back to the idiom of co-production, and I totally agree. What is interesting is that the idea of law's passing comes from an anthropologist of the moderns who knows very, very little about the law, actually. And I thought so it's obviously not an exact science, and it's probably not a complete insight. But what I like about it is the idea of working along a chain of events and persons and things and repairing the disconnect. But that can happen in a constitutive manner, and not necessarily transparency. But of course, you're right. And the passage of law sounds like something, yes, that's less than constitutive. And I would definitely agree with you there, certainly. Yeah.
Terrific. We have a question from Guinevere Saltmere. If you want to raise your hand, then we can locate you quicker and unmute you. I think you're muted. Great.
Hello. Thank you. It's a bit of a challenge to ask a question. Thank you so much, Horatio, for that inspiring us to think beyond the pale. I feel that my question is a little bit pedestrian, but I don't know if you can see it in the chat.
Yeah, I can see it.
Oh, yes. You can.
So it's basically, asking whether we should still be looking to trials, right? When we're talking about civil procedures, since the trials of the vanishing trial, I mean, that's a Mount Gallant expression. So I wonder if you can speak to that. I worry about being superficial in the negative way if we focus too much on the trials and our reflections on comparative civil procedure. Thank you.
Obviously, that's a fabulous question. To a certain extent, the trial seemed an evident thing to talk about just because of trial studies. In other words, I too flipped the process and looked at the ways in which people are looking at trials, rather than wondering what the role of trials is in a wider framework of the passage of law, if you like. I think that some of the lessons, and particularly, maybe I'm a bit obsessed by this, but particularly the idea of law's specific ontology, I think it is sort of emblematically illustrated by trials, because that is the traditional place of expression of sovereignty, let's say. But I think that we can usefully work out from trials to other things. There again, I may be wrong. I think obviously, but there again, I'm not a specialist in this, and I think that people who are doing civil procedure are far more better equipped to answer this than me. But it does seem to me that at least in legal theory and epistemology, one of the big problems now is how can we be lawyers in a world where artificial intelligence is sort of creating the norms, in other words. And that, of course, has got nothing to do with trials. So can we learn something from the way in which law works out in its conflictual procedural way, and then transpose it in a more contemporary context? I'm not sure. I think we can, but I think that there again, you unsurprisingly, and by the way, it's great to interact again. You've pointed out to this shifting focus of law in general, and then of course procedure that comes up in other ways. Things like, I think you can understand things like mediation very much in the terms that are described by Latour. Perhaps some of the other things are a little bit more, and even then, I don't know. I think one might be able to sort of transpose, yes.
Terrific. Do we have any other questions here? Burkhard? And I think if you have questions, better bring them up now because we're running a little late and I want to make sure that Timu has his full time. But Burkhard.
Very short remark from my side. I liked very much the idea to look at the trial. It corresponds a little bit to my own experiences as a traveler. You have recommended to us the article of Frankenberg. And when I travel abroad teaching procedural law, comparative procedural law, what I always do is to go to the court and to attend a hearing.
Yeah.
Even when I do not understand the language. Only after this visit, I have a better idea how a foreign system is functioning. And I would enlarge it even a little bit more. You already spoke about emblematic issues. Courthouses are also extremely important in this regard. Where are they located? How are they organized? You can also see how files are organized. And I will never forget when I was in Santiago de Chile, I was really impressed by the central courthouse. And if you go to China, it's so different. And I think this is something which is very helpful. What we are doing in our project here is to combine people from different jurisdictions with different backgrounds to talk about procedural law and procedural issues. We have to find the right ones. Margaret, I'm fully with you. But on the other hand, what we have already is a broader perspective of people with different backgrounds who have to open this and to make it clear. Then the groups will work very well. And our first experience with national reports and has been quite encouraging, I have to say. And what we really do need in addition, and here I, Horatia, agree again with you, is broaden our perspective. If you go with a psychologist to a hearing, and I have done this from time to time, and you ask the person how he or she has seen it, it gives a totally different impression. So we have to start with somewhere. Trial studies might be a very good idea how to make it. And of course, we have also to ask whether they are still important and whether we have to look at other issues. So this is not a question. It's rather, I really agree with you in this area.
It's a wonderful observation, the idea of going to foreign place to understand foreign law through the trial. And of course, you're absolutely right. One of the disciplinary registers that one could use is urban design, you know, the power in the city. And obviously psychology, psychiatrists, they're wonderful psychiatric studies, that's more on criminal law, of course, but you know, how things, the power relations within the courtroom, and perhaps sometimes the power that the you know, the great criminals exercise over the people who are attending in the courtroom, including the judge. But anyway, yeah, thanks for that. That's a great remark.
I mean, I think Judith Resnick actually had a recent book out on just photos of courthouses as being kind of symbols of justices. And so again, bringing us back to mind, courthouses and trials is still a focal point. All right. I think we're really pretty much out of time now. So why don't we take, I'm trying to remember, Henrik, how many minutes of a break before we come back and for our second presentation? 6 minutes? Okay.
15 minutes, Margaret. Sorry about that. I couldn't mute myself. 15 minutes.
15. Wow. Okay. So please come back in 15 minutes. We're leaving the screen on. So if you have, if you want to chat amongst yourself about Horatia's wonderful presentation, please do. So welcome back. I hope everybody had a nice break. So our next speaker is Professor Timo Raskala, a wonderful scholar, colleague and friend. He is the author of the prize-winning book, Legal Orientalism, China, the US, and Modern Law, published by Harvard University Press in 2013. And he's also the co-editor of Schlesinger's Comparative Law Foundation Press. Professor Raskala is with Emory University School of Law. He's also an elected member of the International Academy of Comparative Law and has received numerous national and international awards, including fellowships at the Helsinki Collegium for Advanced Studies, the Institute for Advanced Studies in Princeton, the American Council of Learned Societies. So welcome, Timo.
Thank you so much, first of all, for all of you for inviting me and for the audience for being here. I know this is a time when everybody has a lot of demands on their time, so I really appreciate it. I'm also excited because I feel like I've been wearing pajamas for the last year, so I get to look like a professional for about 30 minutes. So that alone is worth the price of admission, I would say.
Yeah.
And sort of, well, first couple of caveats. I am no civil procedure maven, and I'm a little terrified going after Horatia, because especially after her incredibly eloquent and elegant presentation, which really focused very much on the place of civil procedure, the role of form in law versus politics. So I'm well, which maybe it's good. I'm instead of like trying to reduplicate what she does so well, I'm really going to be focusing less on the civil procedure part as such, and more on the question of comparison and comparative method in general. So I hope, and I'm going to take a really global view. I hope that will be helpful as well. So it'll be coming sort of from like complementary but different perspectives. But like her, I'll be very concerned about the kind of boundary marking work that the law does, but at a slightly different places and different levels. I don't have a PowerPoint presentation, so I'm going to be very old school. So just bear with me. So what I'd like to do, partly because I have been under home arrest for so long. What I decided to do a few weeks ago over the winter break, I decided to take a trip across Eurasia by reading Italo Calvino's Invisible Cities, which is a book I hadn't read in a long time. And it turns out it's actually very germane to our enterprise today. So if you haven't read the book, it is marvelous, as Italo Calvino always is. And in this specific book, the conceit or the premise is that the Emperor of China asked Marco Polo to describe all the cities that he has seen on his travels. The book is called Invisible Cities. So let me just read the excerpt that really struck me. Towards the end of the book, Marco Polo says to the emperor, "Sire, now I have told you about all the cities I know. There is still one of which you never speak." Marco Polo bowed his head. "Venice," the Khan said, the Khan being Kublai Khan. Marco smiled. "What else do you believe I have been talking to you about? Every time I describe a city, I am saying something about Venice. Mm-hmm. When I ask you about other cities, I want to hear about them, and about Venice when I ask you about Venice. When To distinguish the other cities' qualities, I must speak of a first city that remains implicit. For me, it is Venice. Right. So the point, of course, is important and perhaps obvious, but no less profound, which is that you can never leave home, right? Even within the field of comparative people, there are folks who will make a distinction between the study of comparative law as such versus the description of a foreign legal system. Well, I think even if you're doing just a description of foreign legal system, that is always still an exercise in comparative law. Implicitly, you're describing the features of that system against another system that you have in the back of your mind, whether you make it explicit or not. What's also noteworthy about the passage that I read is, it struck me, is the protagonist there is a sovereign, emperor of China, who is trying to understand places beyond his realm. And China, importantly, has historically been one of Europe's key civilizational others against which it has defined itself. Except that here, of course, the Chinese emperor, the sovereign, is in fact a projection of a European author's imagination, right? So there are a lot of levels, multiple levels of projection going on in just that literary exercise. We have a 20th century European author imagining a late medieval Chinese emperor who in turn is trying to grasp foreign cities through the eyes of a 13th century European visitor, right? So I think just that short passage illustrates at least a couple of important things about comparative law, which is that it is always an imaginative enterprise. It is always, or nearly always, refracted through the eyes of a sovereign, whether real or imagined, and is always a historical act that takes place within a geographical and political context. So with my remarks today, I will start with the big picture, with literally a global view of the historic enterprise that we today call comparative law. In the Middle Ages, for example, or the early modern period, it wouldn't have been called comparative law. It would have been just called the study of law. All law at the time was comparative. In a time or age of legal pluralism, there were multiple sources of law and sovereignty before the nation state monopolized lawmaking, or at least purported to. After I draw that really big, literally global picture, I will suggest one comparative method that I am partial to. I'm not selling it as the method, but it is a method. And I'll finish by giving a concrete example where I try to deploy that method from my own work. But let me start a little bit of intellectual biography, just because I think, like I said, you never leave home, and all comparison in some sense is both personal and political. So I grew up in a small country on the northern edge of Europe in Finland, but I was educated and I have spent the bulk of my professional life in the United States. Yet I have also spent most of my life, all of my adult life, basically studying Asia, as well as working and living there. So in a sense, having always been suspended, circulating among 3 different continents, I would say comparison is literally the only way in which I know how to live. And that is literally just the way in which I look at the world, right? So I cannot not compare. So for me, that's almost existential. But as to comparative law specifically then, well, I came to the study of law by way of area studies. I had studied Chinese history, Chinese philosophy as an undergraduate. I got a graduate degree in the field as well. And well, the academic study of Chinese law indeed belongs under the rubric of comparative law within the kind of legal scholarly taxonomy, which is to say this academic study of foreign legal systems. Nonetheless, I actually came to believe quite early on that it's really difficult to do comparative law, especially in our age of globalization, without thinking about it in relation to international law as well, whether implicitly or explicitly. And I've come to believe that a truly comparative understanding of, for example, Chinese law must account for China itself as a sovereign subject in terms of international law as well. So I think that insight also applies to other states as well beyond China, at least if you're studying any legal order that belongs to a non-Western state. So let me try to elaborate on that a little bit. So I'll start by saying, well, let me try to distinguish between this, the scope of comparative versus international law. According to conventional wisdom, international law tends to focus on the universal, the supranational, whereas comparativists tend to focus on the local and the particular. I've always been more interested in the particular, which is presumably one reason I've been drawn to comparative law, at least initially. And I resisted the siren call of international law for a long time. Universals have always seemed very abstract to me. I don't know that I ever met one. I don't know that would be very interesting. What does it smell or taste like? Probably nothing, right? However, I came to appreciate the relationship between comparative law and international law quite accidentally. I'm very interested in the history of the museum. So I was reading a book by the art historian Douglas Crimp, which is called On the Museum's Ruins. And in that book, he describes his own scholarly trajectory. He talks about how his interest and scholarship has moved from the study of the artwork itself to the study of the museum, from the study of district art to studying the institutional framing conditions for their existence in the first place. Well, it struck me that perhaps my growing interest, reluctant interest in international law was a similar shift. The museum is a kind of representational matrix that constitutes certain objects as art. If you take a soup can and put it in a museum, it becomes art. Similarly, we can say international law constitutes certain normative communities as states. So just as art critics are called upon to critique, describe the objects that museums house, so comparative lawyers are called upon to analyze the national legal systems that international law frames for our study. But from that perspective, then, when we look at them together, we can think of international law and comparative law as a kind of joint cultural, political, epistemological project that has transformed the entire planet into a juridical formation consisting of nation states. It's an enterprise that nationalizes and effectively privatizes culture by consigning it to the domestic sphere of each state and then leaving international law in an ostensibly acultural or supracultural space. Moreover, I think in this dialectic of universality versus particularity, there's very little room for any kind of radical political or cultural difference, the kind of difference that is not easily recouped within a larger state-based liberal logic. We can also think of this view as part of a larger style of political organization, which the sociologist Timothy Mitchell has called the world as an exhibition, a way of thinking about the world as if it were a kind of art gallery or a living museum, if you want to go back to my original metaphor. So international law then provides the structure for displaying the pictures at this global exhibition. Comparative lawyers are assigned the task of painting exotic little portraits of each national jurisdiction within these prefabricated frames. Well, as I think the analogy suggests, a kind of conventional opposition between universal international law and the analysis of particular national legal systems is ultimately not tenable. Universal norms can never be considered only in the abstract. They have to be ultimately translated into and understood in the particular idiom of some local actors in some place at some time on planet Earth. So without the mediation of comparative law, international law would be literally unintelligible. At the same time, comparative lawyers' descriptions of the particular and the local are also by definition exercises of translation, explaining one legal system in terms of another, which assumes the possibility of communication across local differences. So both conceptually as well as practically, the universal and the particular are part of a single dialectic, if you want to use the Hegelian vocabulary. You could say the relationship is supplementary if you post-structuralist. But in any event, that's obviously a very particular way of visualizing the world, a very modern one. We can think about it also in relation to Martin Heidegger's really interesting essay, The Age of the World Picture. In that essay, he observes that modernity is defined by the emergence of the world as a visual object. For him, the notion of the world picture, literally built, refers to the specifically modern idea that the world can be conceived of and grasped as a picture. So it's not just that there's an older Weltanschauung that changes to a modern one. It's the notion that the modern world becomes a picture at all, or picture in the first place, is what distinguishes the modern world picture from its predecessors. If so, together with Mitchell and Heidegger, we can think of law as a kind of transnational political and cultural form that imagines and organizes differences among peoples in a particular way. It is a kind of grid of intelligibility that makes the modern world itself thinkable in the first place. At least on the surface of this picture, then, it has given a kind of global division of the universal and the particular. Universal international law, particular comparative law. But embedded then deeper in this worldview is an assumption of a kind of global commensurability. We can draw up tables and know the world and understand it. In the field of international law, this worldview is one that buttresses the modern idea of human rights as a universal standard. In the field of comparative law, it has given us what is sometimes called humorously the country and Western model of comparison, comparing one country to another, which is basically the project, and it's perfectly defensible, but a particular project of building taxonomies of legal systems, which is to say this kind of effort to classify legal families in this sort of analogizing legal systems to organic entities that can indeed be classified in a scientific way, like plants or animals can be divided into genera and species, like Linnaeus did in his System of Nature. Although actually more specifically, a lot of this kind of comparative legal families approach in particular really draw specifically from 19th century philology, which has Darwinian predecessors, but basically all these Sanskritologists and other old school Orientalists who were tracing different kinds of genealogical connections among families of languages, and then that was transposed into the field of comparative law, that method. So speaking of Orientalism then, I think it's also important to recognize the colonial nature of the world picture that I have drawn. Even though it is a host to a certain global division of the universality and particularity, universality and particularity are not evenly allocated in the world. So when Heidegger talks about the emergence of the modern world picture, he also adds a political claim to his philosophical one. He says, quote, "The fundamental event of the modern age is the conquest of the world as a picture," end quote. And that conquest of the world has obviously not been just metaphorical, as modernity was in fact accompanied by the West's colonial conquest of the rest of the world. And that's a conquest that in turn has been justified and ratified by the emerging modern international law in the form in which I just described it. And it's actually interesting and no accident that both international law and comparative law became professionalized in their modern form in the second half towards the end of the 19th century at the height of Western imperialism. This was also the period of world fairs and of the institutionalization of the modern museum and of the zoo. All these cultural forms follow a similar logic. As Horatio was suggesting, they display diversity and difference in an objectified, flat form for the visual enjoyment of Western viewers. And they, of course, do all of that by bringing the world to the West. In the end, though, this division of the world into formally equal nation states that constitute a kind of global gallery of sovereigns is indeed a European notion, albeit one that's been globalized by means of imperialism. So therefore, these European notions of sovereignty, law, and political subjectivity have become the basis for standardized global ones. Today, as we call we call that, well, in the 19th century, that standard was known as the standard of civilization. As I suggested, today we call it human rights or some such locution. And that, I think, is especially relevant to keep in mind if your object of comparison is a non-Western legal or post-colonial legal system. I was a little bit shocked when I first started teaching, and Chinese law is my primary field of scholarship. So when I told people that I teach Chinese law, I can't tell you how often people would look puzzled and tell me there's no such thing, right? Which first I thought was amusing, then it became irritating, then it became enraging, and then it became interesting. I was like, what is it that motivates this view, and where does it come from? So in the end, I wrote a book that Margaret referenced, which traces the longer history of what I call legal Orientalism, which is a term by which I just mean a set of interlocking global narratives about what is and is not law and who has it. Moreover, why is it that there is a strong cultural propensity to associate, say, the United States with law, and China in particular with its absence? There's a genealogy of Oriental despotism and so on and so forth. But let me pause. You may be getting a little bit impatient and say, okay, that's interesting, but can we do some comparative law rather than just talking about it and mapping it globally? Actually, I would insist what I have been doing is comparative law. What I just did is I compared international law to comparative law. Usually, we take the units of comparison to be national, like I suggested. There's no reason why comparison has to be horizontal on the national level only, or only among formally similar equal entities. There's nothing about the units of comparison that is predetermined. To be sure, what you find is determined, or at least constrained by what you're looking for, but you are allowed to look for whatever you want. So in fact, even to do comparative law, you must have some idea of what law is, as my China example suggests, right? As far as law is compared, we could do regional comparisons, Asia versus Africa, Africa versus Europe. We can compare legal traditions more broadly, which was actually the older approach, look at Montesquieu, before the rise of modern nationalism, kind of the 19th century country and Western tradition. Or we can talk about, do comparison in terms of legal cultures, legal sensibilities, right? Or trial studies for that matter, across whatever jurisdictions we prefer. So all I'm saying is that the nation versus nation comparison is far from self-evident. What in particular makes Monaco and the United States comparable? Pretty much nothing. New York City and Sweden seem more like comparable units, even though New York City is a city and a lot bigger and more important than Sweden. No offense to Sweden, right? So, I think we need to keep these categories very, very loose. But if so, where does that leave us then? Well, on the one hand, I certainly do not believe that there is some objective way to compare whatever units you choose to compare. We all have histories, backgrounds, experiences. We have no choice but to bring our prejudices, if you will, to the table, which is the Calvino point that I started with. You can go all the way to China, but you've never left Venice, right? In the end, though, there are many ways to compare. There are a lot of different choices, which still doesn't mean that it doesn't matter which way you do it. One key point I think is suggested by my title, which is that whatever else comparison is an act. It's an active undertaking with political and ethical consequences. Whatever we choose to compare, the objects of our comparison are not pre-given to us, as I suggested, we choose them. So in an important sense, it's a fundamental effect, I think, of any comparison that it produces, or at a minimum affirms the existence of the objects that are being compared in the first place, right? They don't pre-exist the comparison in some ontological way. Ultimately, it is through acts of comparison that we create others as well as ourselves and form relationships. So to finish up, let me now try to make it more clear about, by giving you an example, and this comes from my own work. So in 1994, the People's Republic of China promulgated their first ever company law, which was a major kind of political and ideological event, right? As you may recall from way back when China was not yet quite as proto-capitalist as it is today. I was curious to understand what, it was basically a transplant of Anglo-American corporate law, and I was curious to understand what that particular legal document might mean in the context of China. I assume it would mean something different, would be interpreted differently from the way company law is interpreted in London or New York or San Francisco. So I started looking for historical analogs to corporations that might give me clues, but I found none. And I bumped into Max Weber, who's just everywhere. Can't avoid him. So Max Weber has famously argued that one key reason why capitalism failed to develop in China, his word, not mine, well, he says one reason for that was the absence of the idea of the corporation as a legal person. Because most Chinese family businesses, he said, because most Chinese businesses were family businesses, they broke up every few generations, unlike a legal person who is immortal. I was skeptical. So after I kept digging around, I found a body of scholarship by anthropologists, kinship anthropologists, looking at lineage organizations, which I call clan corporations. Basically, extended families pooling their capital in these trusts that they set up in the name of an ancestor. They set up clan rules that tells you how to manage the money, how to invest it. There are auditors, you know, and it's basically a separation of ownership and management. You have bylaws, and they would take these charters to the local magistrate who would stamp it and agree to enforce it, which looks a lot like corporation law functionally, okay? More interestingly even, I also learned that especially in the case of large clan corporations, kinship was often an ex post rationalization for pooling capital. So from that perspective, in fact, it turned out in many of these so-called Chinese family businesses, the notion of kinship itself was both a genealogical and legal fiction that justified the multi-generational existence of what I call clan corporations, right? Much as the notion of personhood in Euro-American corporation law is a legal fiction that allows corporations to exist over time. As a corollary, it turned out then, not surprisingly, that in late imperial China, Confucian family law performed the key functions of corporation law. Well, this is a lot like sort of the basic functionalism that Margaret described in the beginning, right? You try to find, you look at a function that law performs, you look for the same kind of problem in a different jurisdiction and see what legal device they use to solve that problem. Let's say the pooling of capital for large undertakings that require more capital. So there is, it's not a bad or good or bad approach. I would say it's probably better than just kind of formalistic approach, you know, cataloging similarities versus differences on the surface, although you can learn things about that too. Certainly ideology matters. You can see ideological differences too. But there is a kind of universalism lurking at the bottom of functionalism. It assumes that there are certain problems that are universal. It tends to be also assumed that there are certain problems that are best resolved through legal means rather than non-legal means, right? So you could say that my comparing Chinese clans to corporations is, or at least can be, a kind of universalizing move, right? Everything becomes corporation law. I take the Euro-American notion of corporation law and project our domestic legal categories on late imperial China in an act of epistemological violence. Well, to avoid that, what I tried to do next is then to reverse the comparison, reverse the clan corporation analogy. I tried to think about the ways in which, well, in the imperial Chinese legal tradition, family, not the individual person, the family is the master category, the master subject. So I decided to look for ways in which we might think about certain aspects of, say, US corporations and their legal organization as similar to norms of family law. There's the law of fiduciary obligations, the ways in which companies merge and not, and so on and so forth. Even just on the level of everyday rhetoric, you know, All companies think of themselves as families, you know, come join our IBM family or what have you, right? So to sort of recap more schematically. So one way to compare A and B might be then to, you know, sort of, like I said, create columns, differences versus similarities, look at them, which is much of the country and Western style of comparison. It tends to be static by definition, right? Usually, and that's the deeper problem is that usually one pole of the comparison tends to be the standard, right? Either let's say you take the A as the standard and compare how B is similar or different. If you find B different, well, we tend to often interpret difference as deficiency. So, you know, it becomes exclusionary, right? They're lacking XYZ things. China lacks law in the extreme case. You could also, you don't have to find things different and you don't have to be exclusionary. In my example, you could also find similarities, which is perhaps better, but then you end up sort of assimilating them to our standards. Look, they too have corporation law. They're just as good as we are. Well, that's perhaps a less exclusionary approach, but it still takes A or us as the standard. So whether you're sort of finding similarity or difference, whether you end up including or excluding, there's no particular virtue to either of those things. I think it's about how and why we conduct our comparisons. So sometimes people complain that my comparisons are apples to oranges comparisons. What is wrong with that? I am not opposed to an apples to apples comparison. I like apples a lot, and there are a lot of important differences, and I'm very particular about my apples. So although you can learn a lot about apples by comparing apples to apples, to have the very notion of what an apple is, you can only arrive at that by comparing apples to something that is not an apple, say an orange, right? You know, apple contra Plato is not an ontological category, right? So there is no global standard of apple. There may be an EU standard of apple, but there is no global one, right? So another way to think about this, I think, is to say, in order to make A and B comparable and commensurate, we often, I think, in order to make them commensurate, I think we imagine implicitly often that there's some kind of objective third term that allows us to identify A and B in some neutral way in the first place. That might be the case when you talk about inanimate object in the world. Okay, compare the words water in English and aqua in Italian. Well, they actually don't mean exactly the same thing. Water in English, and I don't know the water in Swahili, but if you say water in the Sahara, it means something very different versus, you know, if you say that in the middle of the Indian Ocean, right? But regardless, there is an objective scientific way to define water, H2O. You can go to the moon and look for water, and we can tell whether there's water there or not. However, when it comes to legal, political terms, these are cultural terms. There are no universal standards for us. Well, all we can do is you can explain A in terms of B or B in terms of A. When you do that, what you're doing is you're shuttling between two different discourses. It's translation without an objective referent, but it's still translation. Something will be gained in the translation, something will be lost in the translation, right? You're not necessarily discovering anything objective about the other system, but you are doing something that is of tremendous social and I think of ethical significance. You are relating two things to one another, whether for better or worse, right? So in sum, what I've suggested right now is a method that doesn't necessarily just compare A to B, but tries to explore how A and B come to be constituted as objects of knowledge in the first place. So in a sense, it's a kind of anti-foundationalist method, if you will. It's a balancing act that is all moving parts. So in my example, for example, rather than either taking the corporation as a given or the family as a given in one tradition or the other, and then looking for the analog, I decided to look how these two objects of analysis come to be constituted as distinct and oppositional in the first place. So in the end, I believe in comparison, if only because it's unavoidable. The minute you leave your doorstep, you cannot not do it. So I'll just conclude by quoting the post-colonial theorist Gayatri Spivak, because what she said about translation, I think, is equally true about comparison. She said, it is impossible but necessary.
Wow, terrific. Well, this has been really a terrific two set of presentations, and I think they really do complement very well, because what I'm hearing from Timur really is the opening up, right? So that one of the questions was, how do we pick objects for comparison, right? And essentially, Timur says, you know, there isn't these objective categories that exist up there. It's all either one part of the imaginative exercise, and two, we have to challenge how these objects came to be constituted in the first place. And that really takes us even a step before the comparison in thinking about how we reach our foundational questions in the first place, in the questions that we ask. So this is really, really interesting. Again, I don't know, I want to remind folks that if you have a question, to just either raise your hand or indicate in the chat. And right now we have a question by Marcel Call from the Max Planck Institute. So if you could unmute, I think if Nicole can unmute him, we can have the question from Marcel.
Hey, can you hear me, Margaret Wu?
Yes.
Thank you very much. I think I took so much time to formulate it that I don't want to mess it up by saying it out loud again.
You can read it then.
Yes, please.
Go ahead. You do want to read it, or should I? You go ahead, please. Oh, he's muted again. Okay, Marcel says that his question is, you say you can never leave home. I wonder whether this applies to our project. Uh-oh. What I see is you'll never walk alone. Our team, for example, consists of 5 nations. What would constitute our perspective? Is it detrimental that we cannot discern a clear perspective? I have a thought as to that, but let's hear from Timur.
Well, I'd rather hear from you, but
no. Rather hear from you.
Well, I don't know the sort of the nitty-gritty kind of institutional, structural organization of your project, so I'm going a little bit on a limb, but I think it is terrific and excellent that the work is being done in teams, right? And a team that consists of 5 different nations. I don't know enough what those nations are. If those nations are, you know, France.
I can tell you it's very easy. It's the United States, Argentina, Japan, Israel, Germany.
Oh, that's a good, I approve of that. Okay, it's not all civil law countries or all common law countries. So I think that does give, and it does not give you a single perspective. So I think that in and of itself is an excellent starting point. So I do think my point still applies. Yeah. You can never leave home, but what you can do is, you know, you can invite other people to your home. So you have 5 different people, or however many people you have, from different home countries together. So, and I'm guessing it will not result in a unitary perspective for your team. And I think that's an entirely good thing. It could result in a, you know, minor civil procedure war, or you could all agree on things. I don't know, but I think that's a good thing.
Yeah, I also think it's good. I mean, I would think that what Timur is suggesting is also as a manner of thinking, a manner of constantly challenging, re-challenging yourself, not necessarily saying that there won't ultimately be some conclusions that your team or you in particular would draw. But Horatia, what you have a thought?
Yeah, I'll go very quickly because somebody has a great question coming. It's just about perspective. We're listening to Timu. I was thinking when you were talking about Heidegger and the world as a visual picture, which is a fantastic point. Part of the creation of the other was the invention of perspective. In other words, that was a simultaneous thing. Once we understood that there was such a thing as perspective, that actually was the point in which one could be self and other. So I think that's an important thing to go into your story. And also the whole idea of perspective.
Are you, let me just, can I just interrupt? Are you literally talk about the Renaissance discovery?
Yes.
Like,
Yes.
Yeah.
Yeah, sort of, it goes with the idea of the vision of the world as object. But at the same time, it's the creation of perspective. And perspective, of course, is so central to comparative legal thinking. And of course, that can lead to perspectivism. So you can either be looking at the other as out there, or perspectivism is, well, accepting that you are not at some Archimedean point, but that you are actually situated.
I mean, I have ambivalent views about perspective in that historical sense, because of course the Renaissance perspective, yes, in some sense perspective is, locating objects, people in space, yourself in relation to others, right? So that's absolutely right. But the Renaissance linear perspective is the perspective of an individual. It arises at the same time as the invention of the individual. And the particular individual is the sovereign, right? If you go to these old theaters, who's sitting in the middle box? Everything that happens on the stage is, meant to be observed from that point. Everybody else has a messed up perspective, but the sovereign sits in the middle. So, so in some sense, perspective is what brings us together. It's also what distances us and creates distance from the other. So, so there's not one perspective, but there are many. There's also interesting studies about the way in which we see a picture with linear perspective. We see the depth immediately because we've learned to see it. But people who, I don't know if I'm making this up, but there are some studies of people who grew up in the Amazon rainforest may not be able to see that. You actually have to learn to see that. If you go to my counterexample, always China, you look at scroll paintings. They don't have that linear perspective. The perspective moves as you move along in the picture, which is a very different kind of perspective. So, so I think perspective is key, but I think again, all I'm saying is that there are many different perspectives, and it is very much both how the perspective was constituted in the first place and then how we choose to deploy it. But even if you have that linear perspective that centers the individual, if you have 5 people who have that perspective, you can still see things differently.
Mm-hmm. In the perspective of law as a manufacturer of the nation state is something that actually we need to challenge and consider. Raymond, you had a comment too? You want to share it?
Yeah, thank you very much, Margaret. And thank you, Timu. This is a fascinating talk, and especially like your view and kind of center about the 2 aspects. First of imagination. I think that that's the most important thing for a scholar is, I think, to have imagination and to understand how to think about things and outside of the box. And the second thing is really highlighting the significance of what are the units of comparisons, which I think it's fascinating, and maybe kind of like trying to connect the dots here to our project. So our project is Comparative Procedural Law and Justice, right? But we only center on civil procedure, although it says procedural law. We don't going to I guess I'm not sure what all the other groups are doing, but my sense is that we're centered on civil procedure, not criminal procedure, not administrative procedure, not all of those things. And when we speak about with the other people, we do the comparison between the different nations. But there is a lot what to, I think, also learn, like going back home and kind of like trying to see within jurisdictions, kind of comparison within the same system and understanding what's in there. And just going back to, there is a lot of how to think about that, and generally just a comment, and I would be happy to hear what you think. But Owen Fist and Cover had this great project in the 70s and 80s at Yale Law School, where they wanted to just talk about procedure as procedure, and kind of like break down with the categories of civil procedure and criminal procedure and stuff like that. So I think it's just ideas of thinking about those issues. And I think that your lecture just raises all these like wonderful things. So thank you.
Mm-hmm. Terrific. Any thoughts, Timu?
I have one thought, because I hadn't really focused so much until you just mentioned this, that your project is indeed, of course, about civil procedure and justice, and which is interesting. So I think it would be interesting to think about to what extent in that title is embedded an assumption that justice is procedural, right? Legal justice is procedural. It's not our legal justice is precisely procedural, not substantive justice. We all know that procedural innocence, legal innocence is not the same thing as actual innocence. Legal guilt is not the same thing as actual guilt. Well, I'm talking about criminal law, but regardless, we're talking about process and procedure. And so there is a certain, obviously, and it's not good or bad, but there's a certain investment in procedure, obviously, to start with, and certain assumptions, and you got to start somewhere. So that's a perfectly fine way to start. But I think it's also good to keep in mind then, you all know this better because you're procedure people, really in the end, almost impossible, the near impossibility of maintaining the distinction between substance versus process.
Yeah.
So that's really the only comment that comes to my mind.
Mm-hmm. I think the justice part was added on as an aspiration. Burkhard.
I have a little bit a different perspective I would like to bring in. Comparative law, you have said it, can be very much political. And you also address the different perspective, and that one should avoid to be too much at one home. Let's put it that way. Now we have also a development since 20 years which goes to a different kind of comparison, which is about statistics, court performances, etc. So I'm especially alluding the doing business reports of the World Bank. Do you see any, and maybe some, and if you see any, added value of these approaches? I find them quite interesting, but I would like to hear your opinion on that.
I don't find them, well, I don't know of any value. I find them of very little value. Mm-hmm. There are some things that are accountable, the number of judges, policemen, courthouses, and these are not unimportant things, right? But I mean, those are pretty basic things. Yeah. And once you learn those things, you know something, but I think it's hard to learn any things that are actually interesting and insightful, illuminating rather than merely informative through those things. And so part of it is just like the quantitative nature, the desire for metrics, and the kind of false objectivity that is built into them. You can learn something, but they should be not. What troubles me is that the way they are offered as if they were objective when they're not. So I mean, you could learn something, but we should just present them, in a more measured way. I'm okay with that. What troubles me more about those things is the kind of, especially the World Bank rule of law indices, corruption indices, whatever they have. There's also a pretty clear neoliberal agenda behind them, right? So it's not so much that I object to the method. Every method has its politics, and with respect to those indices and markers, I actually object to their politics more than just their mere fact that they're being used.
Terrific. We have an interesting question from Eduardo. Eduardo Ortega.
Yeah, This was a wonderful presentation. Thank you very much. My concern is about the use of home in your example and the relation between home and nation. Probably because I'm Latin American, in which we are very much nations with a clear common sense, a common language. This is why I'm asking about the use of home, in your view.
Say a little more, like what is it that concerns you?
What concerns me is that in your example, when you compare, you came from home. You cannot avoid. And this is the way in which you introduce your lecture, saying what is described in Calvino's romance. And in that example, it was clear that it was a person from a nation and another person in another nation. And also, when you talk about yourself, you are talking about you in different nations. What I try to outline is not a concept of nation, the concept of culture that can be useful, and in this way you are open and going out from the borders. This is why I'm suggesting to, or I'm trying to ask you to profound the notion of home.
So if I'm sort of tracking your question correctly, I think you're suggesting that culture is a broader category than home. So, and the culture in some ways is more permeable and open. Am I reading your question correctly?
Yes, you are reading my question correctly.
I think that is correct. And culture is always in flux, and it's dynamic and it's changing, which is part of the problem with this country and Western static comparison. It doesn't take that into account. But it is also still true that you also can't, wherever you go, you also take your culture with you. It doesn't mean that your culture doesn't change. It doesn't mean that you don't change, but that is always in some sense the point of origin where your transformation that we go through our lives begins, right? We have to start somewhere. There's a beginning point, and for each of us, it is our home, our culture. The idea of home itself, again, also is a cultural notion. You know, whether we constitute our home narrowly as our household, whether, you know, if you're like a nomadic person, it's not even a place, it's, you know, your tribe, which is a much larger entity. So, I think I was using the word home in this kind of larger metaphoric sense. However you define your home, and we can define it sort of more expansively or more narrowly, home for me was just sort of the point of origin where you start your journey, right? So, so in that sense, I don't, I think we're probably more in agreement than not. But I mean, and of course, it's a common trope. It's like, you know, in national politics, you know, homeland, nation is our home, you know, which, you know, it has certain sort of national socialist overtones these days, you know, which are problematic. So even if you broaden the home to your nation, that's not necessarily either better or worse. So, but in any event, I was using the term metaphorically, and I would leave it up to, you know, all of us to define how we define our home. But I do think that in some relevant sense, we take it with us. It doesn't mean that you can move and have other homes later on, but you always will have some baggage with you.
Mm-hmm. Terrific. So I see here, Judith had a comment. I don't know if you want to share it orally with us. I don't know if she's on. Judith, resonate? All right. So, Rick.
Hi, sorry, I'm on. I just was fumbling with the inevitable
Okay.
stuff. Sorry, I'll see if I can unfumble. I can't start my video. Okay. Okay.
Okay.
I'm trying to start my, okay. I'm trying to do all sorts of
we
things.
can go to Rick and then we can come back to you.
Okay.
If you
Can
want.
you see me now?
Yeah, we can see you.
Okay. Okay. So thank you all for proceeding.
If you lower the camera a little bit, we'll see more of you.
Sorry,
too.
I'm in the middle. Whoops. I don't know. Here, there. That's better.
Thank you.
Thank you all. In addition to responding to the hesitancy to think that the categories of civil, criminal, and administrative are robust, and the examples crisscross in the United States, talking about home, but in the United States, fines, fees, structure, controlling access to forms of remedies, not just court-centric, and so to conceptualize the either paths to law, people don't call it justice very much anymore, through the categories of civil or criminal or administrative, is to not start in terms of perspectives from the experience of people seeking access to anything for some form of remedy. So that's sort of the first was, these conversations are very much not 70s, but now, some of it under the rubric of criminal, but a lot of it not limited in that regard. So I just wanted to not suggest that that was somehow antique. But the other is, well, I just was, the University College London, UCL, now has a major project, I think with some Max Planck involvement, on COVID worldwide, that is both a comparative contrast, massive data collection to try to understand government and courts' responses across a huge host of domains. So to the extent wanted to compare comparativism circa 2021 and to interrogate what might a project be, it might be helpful to venture to these other pods, which some of which, I mean, the UCL thing, Jeff King and a bunch of people, but UCL at Jeff King, have launched, and there are slides and there's comparisons and there are hundreds of people on Google Docs and there's a schedule and the like. And it seems that it might be one example, and I'm sure cognizant of that being a Euro, having just given two Euro-American examples here, Euro-US examples, not American. I'm sure there are many others that are doing this. And one thing to suggest is, if the question is what nature of data, what nature, I'm all fond of Renaissance parallels and the like, what would be the various methods, and how are some folks understanding themselves as having perspectives beyond their own experience or shore, understanding what it is that they're doing. And so it might be helpful to ask some of those questions before, or to circulate data on some of these array of projects as a way to encourage us all to uncouple some earlier assumptions.
No, you're absolutely right. I think one thing about that I wanted to kind of bring forth is that this is a project involving multiple people, right? So the various perspectives and questions that Timur is asking each one of us to do individually is fantastic. And we need to ask that question, but at some point, because it's a project with multiple researchers, we will have to reach some boundaries. And certainly do the suggestion of looking at other kind of projects to see what kind of structure and what kind of data other folks have been looking at might help inform us in our structure, but yet we would still ask researchers to constantly challenge themselves and their perspectives in their individual assessments. But Rick, you have a comment? And I think we're going over, just one minute.
Fast.
Henri, when do we end? I think we probably should end soon, right?
We were supposed to meet to end at 7:15, but I think we are in the heat of the discussion. So I
Okay,
think
all
we
right.
should
Okay, so we'll
go
just
on,
get,
and people can leave if they have to leave.
okay, we'll just get a couple more. Rick, I'm
Yeah.
sorry.
Well, this isn't heated, but it's a bit of pushback, I think, first on Eduardo's comment. It seems to me that culture and nation don't go together. Nationalism rose in Europe in the 19th century, and there was surely culture before that. Indeed, many of the legal systems are derived somewhat from Roman canonical law. And pushing back in a different direction, I think we do need some parameters in what we're doing. And so I'm sort of pushing back perhaps on what Judith said. This is quite a far-ranging project already. Categories help, but they aren't everything. And if you think back about a decade, we had a conference on old-fashioned categories, civil versus common law. Those are turning somewhat into mist. So I think we've got to try not to overreach as we go forward. We can learn, but we probably are going to end up being fairly functionalist in the context of cultures that give rise to various procedural structures that aren't all the same, but do fit together as operating entities. So that's just a comment and a pitch, at least from my perspective, on what we might really accomplish.
I'll respond very briefly just to the comment. I think your comment is a very important one. Certainly there was culture before, 19th century invention of the nation state. But what I was suggesting is that there's something peculiar about the way in which that the culture comes to be associated with a nation. Before that, culture was a class rather than nation-based concept. There were people with culture and there were vulgar people. Mm-hmm. That culture was called civilization. It was possessed by a transnational nobility, right? So that's why these people had more in common with each other across, Europe than their lower classes. But with these, after these popular revolutions, culture becomes democratized and becomes, belongs to the people. So there's just a reformulation from this class-based civilization to kind of, culture belonging to the people, which is neither here nor there. But I'm just saying that I was using it sort of in that, in the kind of sense of culture by Herder and other 19th century thinkers. So that's just a clarification.
Mm-hmm. Thank you. Any other thoughts? Well, this has been terrific. And I want to really, really thank both Timu and Horatia. I've learned so much. And it's, I have to say, in this COVID pandemic stupor, you've really injected a spur of stimulation in my life at the very least. So thank you so much. And thank you for everybody who joined in. And Burkhard, Louis, anybody, Enrique, thoughts, comments before we log off? No? Okay. All right. Well, have a good day, everybody. Thank you so much.